Greetings, everyone. I'm Chantal Bernier. I'm the National Practice Leader for Privacy and Cybersecurity for Dentons Canada, and I'm with my colleague, Alexandra Quigley, who is also a member of the Privacy and Cybersecurity team, but she's also a litigator, and I think she's therefore particularly well placed for this webinar to essentially focus on how to protect your organization in relation to the new privacy law, modernizing privacy law in Quebec. So if we go to the next slide, before we enter into the subject, I need to share some general information with you. The first one is that this webinar is recorded, which means that you will have a link that will be distributed to you soon after. The second thing I want to mention is that there's a Q&A box, and we invite you to write down your questions, even if we don't have the time to answer them today, now, we will follow up. So it's not wasted. Please share with us whatever question you'd like us to answer more specifically. And finally, I want to mention that you can obtain credits for 60 minutes of professional development with the Barreau du Québec, the Law Society of Ontario, as well as BC. So if we move to the next slide, I'd like to just give you an overview of our agenda today. We're going to, first of all, share with you our objectives in this webinar. Then we're going to answer the questions that you've sent to us in advance. Then we're going to move to how to protect your organization in relation to the new obligations created by the new Quebec privacy law. We've divided it between the preventative measures and then the recourses. And finally, we'll bring it all together with some key lessons from what we have observed in our practice. So moving then to our objectives. What are we trying to do today? What are we hoping to do today? We'll hope to support you in managing compliance. We hope to give you a reading of Bill 64 and now Law 25, the new Quebec privacy law in Quebec protecting the personal information in the private sector. We have done so by really focusing on the new obligations, as well as on the provisions that truly create some form of protective measure for you. And as I said, we've divided it between what is preventative and then what is reactive. But before that, I'm going to ask Alexandra to address the questions that we have received from you in advance of this webinar. You were invited to send us questions, and so we have all the questions you've asked, and Alexandra is going to reply to them before we move to the recourses. Alexandra, over to you.
Thank you, Chantal. So the first question had to do with the scope of the application of Act 25, specifically whether or not it would apply to banks under federal jurisdiction. This is a very interesting question because technically the answer would be no, as banks are federal works, undertakings, or businesses. They qualify under the federal legislation and would therefore not be subject to the Quebec privacy laws. However, there is a very interesting debate here, and there's also an interesting notion in Section 1 of Act 25, which states that it applies to any business that is the carrying on of an organized economic activity by one or more persons going on in Quebec and as they relate to personal information in Quebec. Therefore, the Quebec regulator, which is the Commission d'accès à l'information, which we refer to as the CAI, has already regularly exercised its jurisdiction over federal banks. And therefore, in terms of best practice, from best practices perspective, it may be best for a bank to consider adopting practices that conform with the Quebec privacy legislation in order to avoid any possible issues with the CAI, despite being what is technically a federal organization or a federal works. I will also pass it back over to Chantal, who has a very interesting perspective and experience on this question.
Yeah, I'll just add to this that when I was at the Office of the Privacy Commissioner of Canada, I used to meet with the Canadian Bankers Association every 6 months, and this issue would come up a lot. That's saying the Commission d'accès à l'information is exercising its jurisdiction over us. We do not fall under Quebec law. Can you make them understand this, please? And of course, we'd have to reply, they are completely convinced. Alexandra just described it, that the power to govern the protection of personal information in Quebec is provincial, and therefore they are absolutely legally clear that the CAI does have jurisdiction over financial institutions as others. So essentially, the best practice I have seen is that the financial institution just goes along with it and does reply to the investigation, and that finally, whether the legal answer is one way or another, yes, Quebec law applies, or no, finally, it's easier to and better for the organization to simply cooperate because the legal matter is not resolved. So I just wanted to give this experience with the issue. Thank you, Alexandra.
Thank you, Chantal. Now, the next issue that was raised has to do with, again, the scope of the application of Act 25, this time as it relates to provincial regulators. And so as you'll see on the next slide, we've addressed this issue on a few fronts. Now, there is a variety of provincial regulators in Canada, including in British Columbia and in Quebec, who are charged with ensuring compliance with the different, whether they be provincial or we have the federal regulator, which is the Office of the Privacy Commissioner. They are each responsible to ensure compliance with the various privacy legislation. Now, given that these regulators have powers which are enacted by, again, their respective privacy legislation, their application will be determined regardless of the origin of the individual to whom the privacy information relates, which means from a business and an organization perspective, a business may be subject to control from a variety or a number of provincial regulators and or the federal regulator, which could intervene at any time if there's any accusations or complaints of privacy violations. We've also seen situations, most recently in the Clearview investigation, where we have joint investigations by the variety of provincial regulators and the federal regulator, which will then render a joint opinion or recommendation regarding a specific organization. So this is good to keep in mind when planning for compliance and when planning privacy policies and best practices within an organization. To keep in mind that different provincial regulators may intervene. They may not all be applying Act 25, but they could still have power to intervene with regards to a specific business or organization. Next question that had been submitted following our previous presentation was whether there were specific penalties and fines for breaches resulting from malicious actors or viruses. The answer is no, there are no specific provisions in the Act or subcategories of penalties and fines that would apply if we have a malicious actor or a virus. The way that the penalties and the fines are presented in Act 25 is based on the nature of the violation, whether it be, for example, a failure to comply with the obligations regarding the collection, the use, or the transfer of personal information, whether it has to do with confidentiality incidents or otherwise. The nature or the identity of the actor is not what is necessarily relevant when identifying whether a fine or a penalty can be imposed. It is more the subject and the nature of the violation. Like as we say here, the administration of the penalty or fine will result from any breach of this obligation, again, regardless of whether it is caused by a malicious actor or a virus. We were also asked whether Act 25 has specific obligations which apply to service providers. Now, again, the Act does not include a specific provision that is expressly dedicated or imposed on a service provider. However, it does include specific obligations that are imposed on a third party, which could include a service provider. And so under the Act 25, the third party must ensure that it takes the necessary measures to protect the personal information, which includes guaranteeing an equivalent level of protection for the personal information. And this must be equivalent to what is imposed on his customer or their customer. The purpose of these provisions are to ensure an equivalent and a constant level of protection for the personal information, even once this personal information is transferred to a third party, such as a service provider. We also have an obligation upon the third party or the service provider to use personal information exclusively for purposes which are compatible of the purpose of the initial collection. And so we would not want that service provider or the third party to take the personal information and to use it for something that's completely different or distinct from the initial collection. We also have obligations upon a third party to comply with contractual obligations for the protection of PI. Such contractual obligations can be included in the service agreement between the initial corporation and the third party service provider. The next topic was not-for-profit organizations and whether these organizations are subject to Act 25. Once again, this will depend on the type of activities that are conducted by the not-for-profit organization. So if the organization engages in business activity as defined in Act 25, they would be subject. Now, if we do not conduct such activity, they would not be subject to Act 25, but they could nonetheless be subject to the more general obligations that are provided for under Articles 35 to 40 of the Quebec Civil Code, which has similar obligations to Act 25, mainly as relates to the collection, the use, and disclosure of personal information, the obligation on the organization to obtain consent in order to collect, use, or disclose PI, the fact that this personal information can only be used for compatible purposes, and that the person that is concerned or the individual can have access to its personal information. These general privacy rights would therefore apply to the not-for-profit organization in Quebec, regardless of whether or not it falls within the scope of Act 25. And finally, you also have a right to appeal relating to privacy rights. Finally, another question that was asked regards transfers of the personal information outside of Quebec. We do have a change in the approach under the current privacy regime in Quebec and the new regime under Act 25. Under the current regime, it prohibits a company from communicating personal information outside of Quebec. This is also an important distinction because we're not talking simply outside of the country, but even interprovincial transfers are subject to these rules and these provisions in Quebec. Currently, a company cannot do so without taking all reasonable means to ensure that the information will not be used for irrelevant purposes or communicated to third parties without the consent of the person concerned. Therefore, here in Quebec, consent is essential. What we will now have under the new regime is an obligation to carry out a PIA to ensure adequate safeguards are given to personal information once it reaches its destination outside of Quebec. There are a variety of factors that must specifically be taken into account when conducting a PIA for a transfer outside of Quebec. This includes reviewing the legal framework that applies in the state or the province or the country to which the personal information is transferred. This also includes taking into account contractual safeguards and protections in order to guarantee equivalent levels of protection, as well as verifying that this information is being used for purposes that are compatible with the initial collection purpose. And so all of these factors must be taken into account in order to provide adequate safeguards for this information once it reaches its new destination outside of Quebec borders. And finally, a question that we were asked often is, given that the provisions of Act 25 will come into force as of September 22nd, 2022, when should companies start respecting them? And that we respectfully encourage all of the companies and the organizations to start doing so now in order to take the necessary time to prepare and to adapt their current privacy policies, their practices, and to prepare for the variety of obligations that will come into effect as of September 22nd. To that effect, we also encourage you to consult the guide that we prepared regarding Bill 64 in order to help you prepare and adapt to the new privacy framework in Quebec. And I will now turn it back over to Chantal to discuss the main differences between this act and other Canadian laws.
So the first thing I'm going to say is that while there are main differences, there are also cross-cutting trends. So the asterisks that you see on this slide, we've put to bring out what also corresponds to a cross-cutting trend. So the very first one we want to mention is the fact that this new law does bring increased consent and transparency requirements to a level that does not exist currently anywhere else in Canada. But the reason there's an asterisk is that the former bill, which was Bill C-11 then, which sought to amend the Federal Privacy Act in the private sector, which is the Protection of Information, of Personal Information and Electronic Documents Act, PIPEDA, that bill included also provisions that increased consent requirements and transparency requirements. The Minister of Innovation, Science and Industry has received in his mandate letter of December 16th, the mandate to reintroduce this modernization of the federal PIPEDA. So we can expect that this difference will no longer be a difference much longer, because we will see probably in the Federal Act and in other privacy acts for the private sector that are popping up, so to speak, across Canada, increased requirements for consent and transparency, the whole idea being to increase the control of the individual over his or her personal information. The second one is really unique to Quebec, and that is a clarification of the concept of de-identified information versus anonymized information. De-identified information is when you sever the identifiers from the substantive information, but not irreversibly. So for example, you put a code, you put a hash, but somewhere there's a matrix list that reattaches the identity to the code. So this is when, for example, you want to protect personal information, use it in a manner that will be enhanced, but you want to protect it, you will de-identify. Anonymized is where that severing of the identifiers is irreversible in a manner that means that there is no way that the personal information can be retraced to the individual. So why there's no asterisk, there's an asterisk here is because in the Federal Act, there is a mention, not the Federal Act, the Bill C-11, then the former Bill C-11, there was reference to de-identified information, but it was different from what is now in the Quebec legislation. So that clearly I want to flag is an issue. We're going to have to make sure that privacy law in Canada does evolve in a way where we all have the same definition for what is de-identified and what is anonymized, and therefore what is still subject to protection and what, on the contrary, anonymized information can be used more freely. Then the right to portability, mobility, brand new, that's the right to ask for one's personal information that has been provided to the organization to be transferred to another organization. That is brand new, and it will be in force in Quebec only in 2024, but other pieces of legislation that are emerging in privacy law in Canada, such as the former Federal Act to modernize federal law, also contained that. So we can expect that to be across Canada. Then the obligation to carry out privacy impact assessments in certain circumstances, including for the transfer of personal information outside Quebec, as Alexandra just mentioned, that is truly singular to Quebec. We haven't seen that in any other proposed legislation in Canada or in certain discussions. The closest is that the Ontario white paper consulting on the possibility of a private sector act for the privacy in Ontario does raise the question, saying, would it be a good idea to make privacy impact assessments obligatory in certain circumstances? But otherwise, this is unique to Quebec. Then mandatory parenting agreement for minors under 14. That again, brand new in Canada, and it was not in the former Bill C-11. So in that, Quebec is singular to require specific consenting measures for minors under the age of 14. Then the right to de-index, or also called the right to be forgotten. So Quebec is the first to introduce that. In a moment, I will explain it a little better. Essentially, it is the right to have information no longer disseminated under certain conditions, and it's particular to Quebec, so that's different. And finally, the financial penalties administered by the regulator are a first in Canada. But there's a reason there's an asterisk there, is because actually that was also part of the proposal to amend PIPEDA, and it should be expected in every new privacy law in Canada. That is the trend. Canada is moving from an ombudsman model, meaning where the regulator is essentially a mediator between the complainants and the respondent organizations. Now we're moving to an enforcement model. So that's why there's an asterisk at the moment. This is different from any other privacy law in Canada, but not for long. So if we move to the next slide, it's prevention. So as I said at the beginning, we decided to divide your recourses between preventative and reactive. So the first thing I'd like to share with you is the keyword, due diligence. What I mean by that is that you will not be blamed or punished just because, for example, you have lost personal information, you've suffered a breach. You will be blamed or punished if it's demonstrated that you did not exercise due diligence, that you didn't do all that you should have done to protect the information. So how do you do that? First of all, you need a governance structure to ensure and demonstrate compliance. It is mandated by Bill 64, now Act 25, and it does have some specific requirements. So first of all, the person with highest authority in the organization is the person that the Act considers to be responsible for compliance with the Act in the organization. Of course, for operational reasons, this can be delegated. But when we put these two provisions together, I read that the person to whom it's going to be delegated better be someone who is pretty closely linked to the person in highest authority. Either a direct report or an indirect report, but not too far down, because clearly the Act puts the responsibility on the person on highest authority to ensure that it does happen. The title and the contact information of that person will have to be published. And then the company has to make sure that it implements policies and practices to ensure that it does comply. So that means policies, corporate policies on how you're going to handle personal information, on how you're going to respond to mechanisms of access or rectification, how you're going to protect the information in terms of very specific methods, measures, how you're going to allow some access or not allow, depending on the restricted use and so on. You're going to have to also develop retention schedules because you're not allowed to keep personal information for longer than you need it. You then also have to provide some practices on destruction. It will have to be very clear who does what. Otherwise, it simply will not roll out the way it should. So assignment of roles and responsibilities of staff. And you need a privacy compliant process because there are new rights created, and I will get to that in a moment. The Act specifically says that the governance structure should be proportionate to the nature and the importance of the company's activities. So the sensitivity of the organization is a factor, the volume of personal information handled is a factor, and it has to be approved by the privacy officer, that governance structure. So there's a formality being introduced here around the governance structure for privacy compliance in an organization. If we move to the next slide, a key part of demonstrating due diligence is having a security incident response plan or a breach response plan. The fact is, if you don't have it, then you cannot respond with the diligence that the Act requires, and that's when penalties can kick in. So the purpose of a breach response plan is, first of all, that you be alerted as soon as there is some irregularity on your system. So usually breach response plans will start with indication for staff as to when they should call IT, what kind of activity on the network should make them alert IT. Then IT has to take steps immediately to either shut down the mechanisms or remove access. They know what to do in accordance to what they analyze as the irregularity, as a possibility of an attack. And IT will also identify what kind of personal information, if any, has been compromised. Depending on what kind of information that is submitted to the person responsible for the protection of personal information, who will determine whether the incident poses a risk of serious harm. And if the answer is yes, well, that means the organization must inform, la Commission d'accès à l'information, must inform persons that have been affected, to who the personal information relates, and any organization that could be in a position to reduce the risk, let's say because the organization does have that information as well, or because that information is also protected by another organization, therefore they can come and assist in reducing risk. No matter what, a breach response plan must be in place to make sure that if indeed a breach does occur, and sadly they occur all the time, there is a manner to respond with due diligence, and therefore, should there be consequences, such as an investigation by the Commission d'accès à l'information or a challenge by individuals, there's evidence that you've done all you could, which is, as I said a moment ago, the best defense. If we move to the next slide, then privacy impact assessments are totally new. So now you will have to do a privacy impact assessment anytime you have a project to acquire, develop, or redesign an existing information system or electronic service delivery system that involves the processing of personal information. And you're going to have to submit that privacy impact assessment to the privacy officer from the get-go to make sure that it is done properly. Again, that obligation to make the PIA is proportional to the sensitivity of the information concerned. And of course, the purposes of use can also be more or less impactful. The volume of personal information, the distribution of the personal information. So the PIA has to be proportionate to all of the risks that could arise. As Alexandra mentioned just a moment ago, PIAs are now necessary to transfer personal information outside Quebec. Here, I would like to share with you the best practice that I see now. Companies that do one PIA for their entire storing outside Quebec. What they do is they go through their supply chain, identify where their suppliers store personal information, the personal information that they transfer to them, and assess the risk for each destination, in other words, each country. And then, on the basis of that risk, either choose to no longer use that supplier or to go on using that supplier, but adding protection in the contractual clauses, adding contractual clauses for that supplier to really mitigate the increased risk of that destination or another. So it's one PIA for the entire transfer, not each transfer, but it does give an organization exactly its risk exposure and a good mitigation strategy. If we go to the next slide, then that's the second category of preventive measures that an organization should take, and that's enhancing the terms of consent, because they are now new and higher. So, for example, a moment ago, I mentioned that there are now specific consent mechanisms for minors. Less than 14 years old requires parental consent. Between 14 and 18, it can be either. We're going to have to see how that pans out, but I think we can fairly expect that it will be according to the sensitivity of the personal information. One thing is for sure is that if your enterprise in any way receives personal information or provides activities for minors, then it'll be important to update your consent mechanisms in that regard. Also, now consent must be specific to each purpose. So you really have to go look at your consent mechanisms to make sure that each of the uses of personal information you make are subject to distinct consent. That is now the requirement by law. It will be when it's in force. And finally, withdrawing consent will have to be as easy as to give it, and therefore it must have a clear, obvious function to withdraw consent. If we move to the next slide, that's the other measure to protect yourself, is to improve transparency. Section 7 of the new act gives new requirements, what must be disclosed in a privacy policy. So important to update the existing policies to match that. Then you'll have to be transparent about your uses of technology as to when they are, when it relates to identifying an individual. And it will also be essential to make those functions obvious so that the individual can actually manage them. Also, this is really borrowing directly from the General Data Protection Regulation in Europe. You will have to declare in your privacy policy or at the time of collecting personal information when that information will be the object of an automated decision, exclusively automated. For example, let's say a credit card application that goes through an automated decision process to simply say yes or no immediately, that will have to be declared. And if we go to the next slide, then this all brings your necessity to develop response mechanisms and guidelines for all these new rights. I just mentioned that you have the obligation to declare the use of automated decisions where the automation is the exclusive manner to take the decision. Well, now individuals will have the right to access the personal information that is used to make that decision. They will have the right to request rectification of the personal information if it is not correct. And they will have the right to submit to a company employee observations to have the decision reviewed. So definitely, organizations need to create mechanisms to respond to that. The right to forget to de-indexation that I mentioned a moment ago, that means, for example, a individual can ask for the cessation of dissemination of personal information. It is subject to a series of conditions. Well, you'll need a mechanism to apply that. When do we say yes? When do we say no? In relation to the conditions that the Act applies. Then the right to portability that I mentioned a moment ago. The right to disclose to another body, which is also what we call the right to portability. So that's the right to an individual to ask for the organization to transfer to another organization the information that the individual provided to it. And I want to underline this because it does not apply to the information that the organization has created or inferred about the individual. For example, a profile. It only applies to the information that the individual has provided to the organization. But, and that will be enforced in 2024, so you have some time, but you do need to have a mechanism to reply to these requests. All of these rights are subject to conditions, and they're not really easy to apply. It can be quite tricky. For example, the right to forget, well, the request is subject to the fact that the prejudice the person will suffer is higher than the public interest is in disseminating the information. I mean, that is not an easy balancing act. So you'll have to develop guidelines for your staff to be supported in implementing all of these new mechanisms. If we go to the next slide, then that is where we get to remedies. So say you've done all of this and you have due diligence. Well, sadly, there can still be a challenge. And that's where Alexandra is going to take you through the remedies that you can use to protect yourself in that circumstance. Alexandra?
Thank you, Chantal. As you'll see on the next slide, a first remedy is available regarding abusive claims. Now, this is very interesting because this remedy is available to corporations under Section 46 of the current Act, and this will be included in Act 25 as well. And so this is something that you could already use if your organization or your company is faced with abusive claims. Now, the nature of the abuse can come in the form in the number of complaints or claims that are filed by a given individual or an organization, the repetitive or systematic nature of these claims, and whether or not these claims or allegations clearly do not comply with the purpose of the law. In such situations, you can turn to the Quebec regulator, which is the Commission d'accès à l'information, or the CAI, and request that they dismiss these requests given that they are abusive. It can also take the form of a request for additional time to respond to these abusive complaints and to make the necessary representations in this regard. And finally, the saying that they are presented as frivolous or in bad faith, and that the regulator should decide not to hear it at all. And so these types of recourses and remedies can be very useful in order to avoid having to devote a great number of resources, of time, and possibly even of legal fees to respond to such abusive claims. You could have a way in order to circumvent or to limit what is necessary in order to defend yourself against such claims. The next available remedy, which is also available currently and will continue to be available under Act 25, is the ability to contest a request for rectification. So as Chantal explained, an individual can request that a company correct their information or the personal information if they claim that it is not correct. In such cases, however, If you can prove that the personal information does not need to be rectified unless it is communicated to the company by or with the agreement of the individual. And so once again, these remedies can be very useful in order to limit the scope of a complaint or how much energy or resources will need to be devoted to it, when combined as well with the necessary infrastructure and best privacy practices in order to be able to respond to a request for rectification and to limit it when it is necessary to turn to the remedy that is available under Section 53. The next remedy has to do with appealing and contesting decisions that are rendered by the Quebec Privacy Commissioner. And so this applies to a first to final decision that is rendered by the Quebec Privacy Commissioner. This can be appealed before the Court of Quebec regarding any question of law or of jurisdiction. An appeal is also available to a company when there is an interlocutory decision by the commissioner. Appeal in this case is available upon following a request for leave from the Court of Quebec. A decision can also be contested or challenged. This is available when faced with an order by the CAI Surveillance Division. And once again, this decision can be contested before a judge of the Court of Quebec. Once again, these are available under the current Quebec Privacy Act and will be continued under Act 25. The next available remedy is under Section 90.4 of Act 25. So this is a new remedy that is available and is the ability to make representations to the Quebec Privacy Commissioner before an administrative monetary penalty is imposed. And so you must be able to first be notified that such a penalty is being imposed on the company. You must also have the opportunity to present observations and to produce any documentation or evidence to complete the file and the representations. This is useful as a possible remedy in order to contest or to limit the possible penalty that can be imposed on a corporation, and is a particularly useful tool when it is combined with an important and an effective governance structure along with internal privacy policies, which can help demonstrate compliance. And so if these measures are already in place before the regulator becomes involved in a situation, they can then be produced into evidence in order to demonstrate compliance and that serious measures have already and have always been taken by the corporation in order to both ensure compliance with the Act and to limit the scope of any possible issue for the individuals. The next available remedy is also new under Act 25, specifically under Section 90.6 of the Act, and that allows the company to request that the CAI reconsider its decision to oppose an administrative monetary penalty on the corporation within 30 days of notification of the notice of claim. Once again, the documentation and the evidence that you will be able to adduce in support of this request is key to its success and to its impact on a possible reconsideration from the Quebec Privacy Commissioner. And so the importance of all the preventative measures that were been discussed previously will be particularly important here. And finally, we have a number of factors which would be taken into consideration when determining a sentence. And these once again reflect the importance of having preventative measures on the one hand as they relate to privacy best practices, and on the other as they reflect to or pertain to transparency within your organization. And so the first factor is the nature, the seriousness, or the repetitiveness and the duration of the offense. Now, in this regard, it's particularly important for the corporation to be able to invoke, for example, the uniqueness of the breach, the measures and the efforts that it has taken to remedy it as soon as possible. For example, if you have a security incident response plan that could be given to the CAI in order to demonstrate that you took the necessary measures to prevent a confidentiality incident as best that you can, and as well as all the documents that were provided in response to this, be it in response to the individual concerned or to the commissioner themselves. It is also important to be able to present this documentation and the due diligence that was performed ahead of time by the corporation, as well as in response to any incident or possible violation, in order to prove that the company was neither negligent nor reckless. It is also important to have a security plan in place and to have measures to perform the necessary risk assessments if there is a breach or if there is any other violation of the Act, in order to prove that the violation that has been presented in front of the CAI was not foreseeable and cannot be prevented, or what measures were taken in order to prevent it or to limit its scope. This is also important in order to demonstrate that the company did not attempt to conceal any violation or offense, and that it did everything that it possibly could to mitigate the consequences of a breach or the offense. Finally, by reacting quickly and having the necessary infrastructure in place to do so, this will allow it to not only limit the risk of harm to the individuals, but also possibly limit the number of persons that are exposed or that involved in an offense. This will also help mitigate or limit a possible sanction or sentence that could be ordered by the CAI or by a judge following a violation of Act 25.
So then we move to the key lessons on compliance, and those lessons we've really are really lessons that come from practice, from having seen so many companies deal with these challenges. The first one, I repeat myself, but really due diligence is your greatest defense. Focus on that. Make sure you do the right thing. Also, the governance structure is essential. You will not have compliance if you do not have an internal structure to actually govern it, and if you do not have privacy policies and practices to actually implement it. So that's critical. The third point I want to make, and this is really after having audited a big, very sophisticated Canadian organization that is global. They asked us to review their process in complying with the General Data Protection Regulation. They said, can you please come in and tell us whether our process to bring us to compliance was the right process? And I was struck by the fact that they had started so late. And because they're so big and they're so sophisticated, they did manage to comply in time with the entry into force of the GDPR, but with so much friction, with so much resentment, it was such a difficult process that really they should have started much earlier. However, and this is the fourth point, they did something that really impressed me, is the Chief Privacy Officer did her gap analysis. So she knew exactly everything they needed to change. And she had prioritized in relation to risk all of these gaps. And there were gaps that frankly didn't read much attention for a long time, so that she was really be able to be very effective in how she brought the organization in compliance with the GDPR. And the fifth one is document it. Alexandra just described to you all of the defense arguments you can put forward. Well, document it. Have your privacy policies well drafted in a way that you are comfortable sharing them with the outside. Your security plan, of course, a huge chunk of it should remain secret because otherwise you're going to get circumvented, but have a part of your privacy plan that can be shared. Make sure you document so you can demonstrate. That's really fundamentally your best protection.